Welcome to this month's edition of Lunch and Law. We're here to discuss taking away the administrative state's favorite shortcuts. Here today to comment on the significance of the President's recent anti-guidance executive orders is former White House Counsel and Trump Campaign General Counsel, the Honorable Don McGahn. I can think of no better placed person than Don to talk about these executive orders. In addition to overseeing the appointment of 2 Supreme Court justices during his tenure at the White House, who seemed to be prepared to push back on the administrative state, I might add. Don spearheaded President Trump's deregulation efforts, including the early 2 in, 1 out, or excuse me, 1 in, 2 out requirement. Fix that, okay. After leaving the White House, President Trump appointed Don to the Council of the Administrative Conference of the United States, a nonpartisan agency that oversees process improvements in the administrative state. Don is also a former member of the Federal Election Commission appointed by President Bush in 2008, as well as former general counsel to the National Republican Congressional Committee. He received his BA from the University of Notre Dame and his JD from Widener University. He is currently a partner at the Jones Day Law Firm here in DC, where he is the practice leader for the Government Regulation Practice Group. Don, welcome to the New Civil Liberties Alliance.
Thank you for having me.
By way of background for our audience, President Trump signed 2 executive orders on October 9th of this year. EO 13891 is formally entitled Promoting the Rule of Law Through Improved Agency Guidance Documents. Informally, it has been called the Bringing Guidance Out of the Darkness Executive Order. EO 13892 is entitled Promoting the Rule of Law Through Transparency and Fairness in Civil Administrative Enforcement and Adjudication. Informally, it has been termed the Transparency and Fairness Executive Order. Rather than summarize these EOs now, we will discuss them as we go along. But I do want to say that the EOs are already working. My colleague Harriet Hageman has been leading NCLA's fight against the U.S. Department of Agriculture over a guidance it put out earlier this year on radio frequency ID tags for cattle and certain other livestock. And the guidance, in our view, is unlawful because it purports to overturn a previous notice and comment regulation that had no basis, and the guidance had no basis in the statute. Once the EOs came out, I'm happy to report USDA has backed down and we're now working to resolve that lawsuit. Don, before I get into the executive orders themselves, I'd like to get your perspective on the administrative state. What does that term mean to you when we're talking about that?
It means trouble. It's become a much more common phrase to capture sort of the alphabet soup of bureaucracies in DC. These things, let's be honest, there have been some administrative agencies going back to the founding, right? There's the principal historical core cabinet of the president. They had their decision-making authority. But really, it began with Woodrow Wilson, this idea of let's just get political decisions away from politicians, and somehow that would allow for this sort of perfect decision-making, a utopian view of how we govern ourselves. It hasn't really worked for the most part. Someone has issues where they think it worked, they can certainly speak up. But I'd like to try to be fair. I'm sure something's good in there somewhere. But for 100 years, what you've had is a steady growth, regardless of who's won the various elections over the years, a steady growth and movement away from elected officials making decisions into unelected bureaucracies that have managed to create a bunch of layers of additional bureaucracy impediments to avoid review of their decisions, transparency of their decisions, and ability to really engage with them over what their decisions are. It's the sort of thing that when you have a constitutional system of government with 3 co-equal branches, it doesn't seem to fit in, because it seems to, in the modern age, it's become a hybrid of all 3 branches. And so that's ultimately, when I think of administrative state, I think of places where people try to do quasi-legislative power, enforce that power in a kind of executive capacity, and then adjudicate it themselves. So,
sure.
Yeah.
And combine all those things. Has this been a priority of President Trump's from day one? Why is he so committed to stopping regulatory overreach and abuse?
Well, he's a guy who, in his gut, has certain views of how things ought to operate. If you look at his background, he is not someone who comes from the pristine corporate boardrooms of polite society. He's one who's kind of done it his own way, and as a real estate developer and someone who has his own style, instinctively understands the burdens that red tape can put on entrepreneurs.
They have some of those in New York City for builders?
Apparently he understands what City Hall can do to you when you're simply trying to create opportunities for others and expand the economic pie. So he coming in the office, he had tussled with City Hall, so to speak, time and time again. So you have a president right now who feels it not in some theoretical abstract way, but in a very real life way where he actually was able to see in his own businesses how this stuff can kind of get in the way. So yeah, the answer is from day one, he's committed to this. And you saw that first week, one of the first executive orders was this 2-for-1, where, according to the executive order, for every new regulation that goes on the books, 2 are supposed to come off the books. Some speculated that was going to be kind of a gimmick. One could simply renumber some regs and turn 1, 2, 3 into A, B, and C and say, well, now it's just one reg. But that really didn't happen. What happened was, in the first year, I think it ended up being about 11-to-1 ratio. For every 11 regs that came off the books, only 1 went on the books. Second year was a 4-to-1. So the thing actually really set a tempo and a message out of the gate, and it really came from the top. I mean, this wasn't something that organically sort of came up from below. President came in, very strong view on the issue, and took decisive action right out of the gate, and it's had a significant effect.
What about these latest executive orders? Who deserves credit for bringing those into existence? Is it you, your successor, Pat Cipollone, the incoming head of the Office of Information and Regulatory Affairs, Paul Ray, his predecessor, Naomi Rao, the folks over at OMB? Who gets the credit here?
Well, the president gets the credit. I mean, the president's the one who wants this done, and I guess maybe people could just draft executive orders that they imagine someone would sign someday. But at the end of the day, the president's in charge. He makes the decisions, and this president has certain views that can be carried out in these executive orders. If you break down the recent executive orders, there's mixture of legal concepts in there and fundamental fairness and that sort of thing. So obviously all presidents leave details to others, and then once the order's signed, there's obviously implementation that has to go down. So certainly a team effort to bring this to the president, and certainly going to be a much bigger team effort going forward to try to make sure that agencies actually take the president's directive seriously.
Let's get into the orders themselves. One of the first things that jumped out at me is the requirement that this applies to nearly all of the executive agencies. Is that usual for an executive order, or does this one sweep quite broadly?
I think it's pretty broad. I mean, I think the other thing that's crept into the administrative state vernacular is the idea that agencies really don't report to the executive. People talk about the unitary branch. The unitary executive theory, it's actually not a theory. It's in the Constitution, where actually people in the executive branch really serve at the pleasure of the president. There's been a little bit of fuzz put on that, so to speak, over the years with a couple Supreme Court cases on how you can remove people. But I think it is quite broad.
We're working on those.
And the idea is that it should reach anybody in the executive branch. But that shouldn't be controversial. I mean, if an agency says we're not bound by this, so they really don't want to give due process and transparency, what's that say about what they're trying to do? Really potentially exposes them for what they are.
Sure. Another provision of the EOs is that agencies have to post any guidance that they want to keep within 120 days. I imagine there's a lot of scrambling going on at various agencies around town right now. What happens to the guidance that they fail to put up on their websites after 120 days?
Well, this comes from a frustration many of us have had for years, and I do not come from the academy. I am not someone who deals in the world of theory. I'm a lawyer who has defended many people from regulatory overreach, and one of the things that I encountered time and time again was essentially kind of secret law of various forms. You read the statute, you read the regs, and then it turns out there's a mountain of agency paper, some of which is public, some of which isn't public, that turns out to be the operative norm that tends to be sprung at the worst possible moment if you're subject to the regulation, usually in the enforcement context. And it seemed like it was not just limited to one or two agencies. It seemed to be a move that they sort of collectively developed over the years. And it seemed to me that there should be at least the idea that the stuff is public. And if it's not, then it should not be used. And look, there's two kinds of guidance, right? There's guidance that's kind of okay guidance. If DHS issues a memo to TSA to instruct people on how to look at suitcases in the line, okay, that's probably good. You really don't want them sort of, improving on what they're going to do in the security line, because the remedy is basically you got to throw the bottle of water in the trash can, right? Not the end of the world. Even at the Cato Institute, that's not the end of the world, right? That's not this. I love this audience; they laugh at that joke. But there's other kinds of guidance that essentially creates a whole new regime of law that is then selectively used depending on when they need it, and that's the kind of guidance that these executive orders is really getting at.
Sure. So having it all in one place makes it easier to comply on the part of the regulated parties. Is this also a first step in helping the White House get purchase on exactly how much guidance is out there?
It certainly is. I mean, you would think someone in the executive branch would be able to tell you like how much law actually exists in the executive branch. You really can't. I mean, it's everywhere. I think it was Justice Scalia talked about this years ago. The idea that in Roman times the law was public, but it was like small font at the top of the obelisk, and you couldn't really realize that you weren't supposed to do that. But then when they caught you, they'd say, "Oh no, it's public. It's posted in public." That's not really public. And I saw this when I actually was appointed to run the Federal Election Commission quite a while, I guess over 10 years ago. They had a number of enforcement matters and the like that were not really meaningfully publicly available. It was on microfiche in their public records room. And I remember being a junior associate years and years ago. It was a big day to do research of federal election law. You got to go to the FEC. You got to go through microfiche, flipping through. I mean, that was 8 hours a day. Just that was ridiculous. And then once I got out of like worrying about billable hours for the sake of billable hours, I realized this was sort of not the way to run a railroad. And when I was at the FEC, one of the things we did was put all this stuff on the internet. And then the secondary thing, which you see in this executive order, is if you don't make it public, you can't possibly be of real legal effect.
Mm-hmm. Does it also shift the burden over whether something even is a guidance by saying if it's a guidance it has to be on the website?
It does, yeah, it absolutely does. Because previously, if the agency was coming after you, you would have to you would have to kind of prove it was not really the law and that kind of thing. This puts down a marker and essentially holds the agencies accountable before you act, before they try to regulate you, that they have to be a little more transparent and they have to at least have it in a place where you can find it.
The agencies are supposed to, under the EOs, promulgate regulations implementing them within 300 days. NCLA has filed 21 different petitions for rulemaking over the last year, asking federal agencies to eschew reliance on binding guidance, and we've met with some resistance. And so I'm wondering how readily you expect these agencies to comply with the EOs and promulgate these regulations.
Well, if they think they're in the executive branch, there's an executive order that says they have to do it. There will be certain probably opposition, slow walking, the usual sort of thing they do, but then the question will be, if you don't do the rulemaking within a certain period of time, can someone then go to court? The answer is probably yes, right? So again, it is something that will hold them accountable. And then it provides another tool in the tool chest if the agency has not promulgated some sort of public process by which they will issue their guidance, to then rely on guidance that was not only not issued through that process because, well, that process doesn't exist. So it will further complicate their ability to spring kind of surprise changes in the law. And that's really the problem with guidance, right? Guidance, like I said, about the guidance about, suitcases in the line, that's not making new law. But oftentimes agencies put out guidance that really seems to be an entirely new rule, oftentimes goes beyond what the rule requires. And then they turn around and hold you to this as sort of a best efforts, kind of a best practices standard. And if you don't adhere to this best practices standard, they didn't say, well, you violated the law. And the argument is, well, no, we didn't violate the statute or the reg. Just because we didn't do your version of best practices doesn't mean we broke the law. And agencies, they don't really have much of a sense of humor. They disagree on that. So, so it's a way to sort of create law going around what should be the ordinary process. But, mandating the agencies to actually now have a process to issue this stuff will give people an opportunity to be heard while it's in the process. It won't be some dear colleague letter from one cabinet secretary to the other opining on what they think the law ought to be, or the like. So it's designed to again, get people more involved. It's kind of like an APA for guidance in a way, right? Where you actually have to, and this is kind of weird because as an administrative lawyer, you think, well, APA, APA is our friend in a lot of ways because at least it makes a process that forces the public to be able to weigh in and the agency to put out rule text and that kind of thing. But with this guidance, there hasn't been a similar corollary, with the commonly called sub-regulatory guidance, which kind of gives it away. That tells you it's not actually a binding norm.
Well, and one of the things that comes with putting it on the website is there's a requirement in the EO that the website explicitly say that this is not binding guidance, or that this does not have the force and effect of law, I think is the way that the EO puts it. Is that significant for it to say that on the website?
Sure, yeah. I mean, that the agency then has to sort of publicly fish or cut bait as to what they think counts and what they don't think counts. Where it's going to get tricky, and I can see this happening, is agencies will always say this guidance is within the scope of the statute or the regs. They have to, or they can't go out and publicly say, oh, this is beyond their statutory authority. Occasionally, agencies have made mistakes and kind of said something like that. But generally, if you're on your game at an agency, you're never going to say you're beyond your authority. So they're going to say the guidance really isn't anything other than just explaining what the reg means, and the stuff is actually within the public reg. So I do see this executive order fixes a lot of problems, but the conflict, it's not going to go away.
Right. It's not a silver bullet.
It shows the president's committed to fixing it, but it's going to take a lot of work to make sure that what he put in this executive order actually becomes real.
Another aspect of the EOs requires every guidance to indicate what regulation or statute the guidance purports to be based on.
Yeah.
Will that
that kind of
the problem you were just talking about?
Yeah, it dovetails off what I was saying. Was sometimes these guidance documents kind of float along, and then the agency, after the fact, has to sort of ex post cobble together the authority for the guidance. This puts the cart before this puts the cart before the horse before the cart, I guess. Kind of like reversing 2 for 1, 1 for 2. Where you have to think about the authority for this before you try to say that it's actually legitimate guidance.
Right. Look at the law first and then write the guidance instead of doing it the other way.
That's right.
You alluded to the problem of final agency action, and that's certainly something that we have encountered here in litigation efforts at NCLA. When you want to push back against a guidance, then the agency typically says, well, this doesn't represent the culmination of the agency's viewpoint on this issue, or even if they concede it is the culmination of the agency's viewpoint, they suggest, well, this isn't the final action that we have taken. And I'm wondering if the EOs solve this problem in the sense that does, from your perspective, does putting guidance on the website constitute final agency action?
Well, it should at least make it an issue that a court can review. The final agency action idea is one of the tricks that agencies have developed over the years to avoid judicial review. You saw this in Sackett versus EPA, right? The poor Sacketts had their land. They wanted to develop the land. The EPA came in, fined them every day, saying that they violated the law. The Sacketts said, we don't think so, and then they went to court, and what did the EPA say? Oh, well, this isn't final agency action. You can't go to court. Well, that doesn't make any sense. Supreme Court didn't think it made sense either, so now we have a nifty due process case saying that you have to actually have due process in agencies, which was, if you really think about it, that's revolutionary to a lot of these folks that inhabit these agencies, and they've sort of engaged in resistance when it comes to thinking about how SACIT applies to them.
They have not interpreted the precedent broadly.
No, that's being kind. No, but it is, the due process concept does apply. But you're all right. They do tend to they selectively read precedent, right? They read narrow, very broad. And I saw this one at the FEC. There were cases would come down. I'd say, this completely blows up this one procedure. Oh no, that doesn't apply to us at all. Really? How?
Right. So one of the other aspects of the EO is that every agency has to set up the ability for someone to petition the agency to take down or rescind the guidance. I'm wondering if putting the guidance on the website doesn't automatically constitute final agency action. Would at least refusing to take the guidance down from the website constitute final agency action that could prompt judicial review?
Potentially. I'm not a judge, so ultimately courts will decide what their view is, but I think it certainly moves the ball in the right direction. And it certainly makes it much more difficult for agencies to play this game where they, on the one hand, want to use guidance as an affirmative norm, affirmative kind of law, but then when you try to challenge that, they fall back and say, well, you can't do that. At least with a rulemaking, you can go to court.
Right.
Rules promulgated, you can go challenge the rule.
Facially, even.
Right. That's my point. There's a whole other sideshow on how that plays out with deference that the courts give and all that. But with the guidance, they slip around that, and then you really don't get to challenge it until maybe it's in the enforcement context. And then you're really kind of in a bad spot because then, they're going to be brandishing voluntary fines and all this kind of thing. And if you go to court, you're going to end up probably, at least once upon a time, although I think it's changing, pretty generous deference given by courts to this kind of stuff. Courts have kind of missed the distinction between statutes, regs, and then sub-regulatory. A lot of courts have sort of taken it all as the same basic thing for deference purposes. So the sooner people can challenge this stuff, I think the better, because it allows for more consistent norms, and then people can predict what the law is. It's the idea of a rule of law society, right? You predict what the rule is, and then you can organize your affairs around kind of a fixed star in the sky. Washington, D.C., you get in these agencies, and it's just it's just an ever-shifting constellation of all sorts of points that always seem to conveniently line up the wrong way, depending on who you are. Right,
or the agency sees a very different picture than the regulated parties when they look at the constellation. Do you think that part of the problem is in the judiciary? Do we need more judges who have experience advising clients on dealing with regulatory matters, or who have...
Potentially. I think we certainly need jurists who take their role as jurists seriously, who are willing to say what the law is, and not engage in what I have viewed as sort of judicial abdication of that role, where under either buying into the premise of sort of the Wilsonian perfection of the nonpartisan decision maker, or the idea of sort of a restraint model of deference. It's really the job of judges to actually read the law and say what the law is. I don't understand the idea that you defer to other branches reading of the law when it's a quick case before you. Kind of, without getting too dramatic, the point of Marbury versus Madison was, I thought we resolved that in Marbury, but the deference doctrines have, in a lot of ways, allowed judges to not really get into the weeds of the law. Now, look, there's certain areas where there's certain expertise that judges don't have, and I guess they have to rely on it, and that makes perfect sense. NASA builds rockets; they actually have rocket scientists. As a lawyer, I probably would not be able to second guess, a NASA rocket decision.
The mix
probably
of fuel
don't want to
in the
right?
booster.
Right. I mean, that's the sort of thing that, okay, if judges start trying to figure that out, that would be a lot of time. But what I'm talking about, what's bled in, what's gone from sort of that kind of expert is to deference to supposed experts that really aren't experts in anything other than the subject matter of the law. They're lawyers, probably, run these agencies, and somehow they get deference. They're not really bringing any special expertise to it that, frankly, a court doesn't already have, and that is how to read legal text. So that's a long way of saying, we need certainly more judges who are willing to do that. President's put a number of judges on the bench, all levels of courts, that have demonstrated commitment to that. Gorsuch is really kind of at the forefront of this. He, on the 10th Circuit, had an opinion. He authored the opinion, but then he dropped a separate concurrence where he questioned whether the Chevron doctrine, which is one of these deference doctrines, is constitutional. And he did not really affirmatively say it is, but because he's a smart guy, he puts question marks after it. But he basically said it is, question mark. And that was really something, that was an opinion that really, I think, had a lot of ripple effects and influenced a lot of people. Kavanaugh has had similar barn burners when he was on the D.C. Circuit. He had a number of administrative law cases. He came at the issue a little bit different direction in the net neutrality case with the FCC, where unfortunately it was dissent, but he got into something called the major rules doctrine, which is something that really Justice Breyer was kind of the architect of. It's a must read. It's another way of taking a hard look at agency overreach. So, the president's first two picks to the Supreme Court are both really known for their administrative law chops. And if you look at the circuit judges, a lot of them were appellate lawyers or solicitor generals for states or things, and really spent a lot of time on cases that involved the reading of legal text, bureaucracies, regulations, separation of powers, this whole kettle of fish that used to be kind of viewed as kind of a sleepy subject.
Including both of the picks for the D.C. Circuit, where so much administrative law is done.
I mean, that's D.C. Circuit. They like to think of themselves as the second highest court in the land. Until you go over the bridge and the Fourth Circuit is there, they don't appreciate that. But they're very polite and shake your hand when you're done arguing. Fourth Circuit, not the D.C. Circuit. But yeah, I think this is another thing where the president has a real vision on this stuff, and his two picks for the D.C. Circuit were both folks who really fought these fights at a granular level, in a lot of ways. Naomi Rao, in particular, was head of OIRA out of the gate. She was a law professor at George Mason. She had, stellar reputation. Wrote all sorts of law review articles on this stuff, and her views are very well known. A lot of this actually it's not just Gorsuch and Kavanaugh. A lot of this is Justice Thomas. If you go to his writings, he's been 100% consistent on this for years and years and years. And so much of Thomas's thinking used to be maybe lone dissents or maybe a dissent with a couple people, is now becoming much more the law. And it was very important, I think, to the president that his first two picks to the D.C. Circuit clerked for Clarence Thomas. That really sends a message as to where the president is on his view of what judges ought to be.
Sure. The EOs also allow the White House to order an explanation from any agency as to why they're not rescinding, I guess, a particular piece of guidance that they're putting up on the website. How do you view that process as working?
Well, I don't go there anymore, so we'll have to see how it works. But I think in general, it makes clear that it reminds everyone, executive power flows from the executive, which is the president, and then by proxy his close advisors. And I think it'll help nudge unwilling bureaucracies in the correct direction, because they can become somewhat insular. And there is this culture of independence for the sake of independence. And I think having that provision in the executive order will give another tool in the tool chest to nudge people toward getting in line with the rule of law.
One criticism that's been made of the EOs is that they don't apply to independent agencies. I suspect that might be because...
Independent of what?
Well...
Yeah. Right.
Exactly.
Yeah.
Independent of
It's a whole
little
other
too
kettle of
independent.
fish.
It is.
Whole other kettle of fish.
But I wonder if part of the thinking there was to prevent the EOs from getting bogged down in litigation and really sort of focus on the executive agencies for now.
The thing about governing, it's about doing what's possible and not doing everything that you theoretically would love to do. And you start with things that are doable, and I think that's probably part of what drives the act. The so-called independent agencies, there's a handful of them. The FEC is one of them, where they tend to be even or odd numbered bipartisan agencies with extended terms, and the removal provisions are a little cumbersome post Humphrey's executor, which is the case that kind of created this idea of these arm's length agencies that don't really answer directly to the president. And getting them under the tent, there's a lot of steps to get there because of some Supreme Court precedent. I would hope they would still take this seriously and do it because, I mean, like I said at the beginning, if you're opposed to this kind of stuff, wow. I mean, that's, you really want, so you're admitting you want secret law, you're admitting you don't want due process, you're admitting you should use, guidance as affirmative law. That's a tough position to be in, even if you think yourself as an independent agency.
Sure. Another aspect of the EOs requires that any economically significant guidance be put through ordinary regulatory review processes. Why does that matter, and how could a mere guidance have a $100 million impact, which is I guess the OMB cutoff for economic significance?
Well, that's a rhetorical question. It certainly can have that impact depending on what it says and what it does and how broad it gets into it. I think OSHA had this. They had this sort of guidance thing where they came out with something pretty big several years ago that certainly had a big impact. So it's certainly possible it can be that big. The economics is something that requires, what's good about it is it requires agencies to at least think about it. Question is, if they don't think about it, is there a judicial remedy? Is something that then causes the action to crater? Potentially it does, because now you're required to review, to actually consider this. There's really two ways of thinking about this, and I'm, I'm from the school of thought where less regulation, more organized regulation, in that it's clearer, more direct, more transparent. The idea of liberty for the sake of liberty is enough of an interest to pursue. There's others who also like the economic impact. Mick Mulvaney, for example, big on economic, the economic impact. He was a small businessman, served in the state legislature, served in the House.
OMB director.
OMB director, now acting chief of staff, whatever that is, is very much a fiscal hawk. And I think just with kind of looking from the outside in now, Mick's kind of been carrying the water on that remarkably well, and his team at OMB, Russ Vogt and others, very much focused on that. I kind of work the other side of the street on this kind of idea of liberty, and the theme is freedom, and works like that. But
that's our side of the street too.
Yeah, right.
It looked to me almost like a push-pull kind of situation where the White House can order agencies to give an explanation to OMB and sort of pull that way, and then this $100 million threshold is kind of a push that says, well, if it's going to be that big, then you have to tell OMB about it and sort of get them involved before this can go out the door.
Yeah, all this is designed to push back on what has become the usual tricks that agencies do. So the idea you kind of have to box them in a little bit because they can get a little slippery.
One of the other requirements at least for the economically significant guidance, is that it has to be signed by an officer of the United States. What's that about?
Say that again.
It has to be signed by an officer of the United States.
The guidance.
A presidentially appointed, Senate confirmed.
That gets into, we'll call it staff issued guidance. Agencies have built up a mountain of paper issued by various levels of the bureaucracy. And then they act as if that's a binding norm and law. And it's really not, because it's not really enacted by the people really empowered to make the norm actually come to life. So the idea is that it has to go up the chain of command to someone sufficiently accountable to someone, whether it's to the president or to Congress or to the voters generally, that they're the ones actually making the decision. It's also there's a hidden power in there. In a way, it helps the people who run the agencies get a handle on what's going on, because oftentimes if you're appointed to run one of these places, the staff has a variety of maneuvers to sort of box you in. And all of a sudden they say, well, this, we've been using this guidance for years, and it went here and there and there. And when you ask, well, who actually signed off on this, it gets a little murky, but there's Chevron, but there's deference, and you get this. There's this variety of moves that they do. So it's a way to have the people empowered to run these agencies, empowered by the president to run these agencies, to actually really get a handle on what's going on. And it's a weapon. It's something in their toolkit they can use to try to get a handle on things down the line. There was a case years ago. Where the IRS, the counsel's office, was giving advice to field agents. And folks wanted to see it. They were kind of curious because, well, the IRS was taking positions they didn't like, and the IRS took the position it was attorney-client privilege because it's from the counsel to the staff. And then the court that ruled, I remember it was district court or DC circuit, it might have been district court, basically said can't do that because it turns out these documents were essentially not just black letter recitations of the law. It had a lot of kind of best practices in there and guidance that was its own form of secret law, right? So that's an example of something down in the bowels of an agency that isn't necessarily promulgated by someone. And then Treasury, General Counsel, Senate confirmed, and there still was layers removed from that position where there was this whole sort of lawmaking going on that was not being made by even an executive branch official in the sense that the EO talks about.
Okay. I think this dovetails into what you're just talking about. The EOs require enforcement standards to be articulated in advance and only allow agencies to enforce public standards that don't cause unfair surprise.
Right.
That'll come as a welcome respite. Is that something that you had experience with either at the FEC or in the White House Counsel's office?
Yeah, well, all of the above, yes. I mean, fortunately, White House Counsel's office, the agencies really don't regulate the White House Counsel's office, at least not yet. I love this audience. You laugh at this is my kind of thing. I remember something in election law, and we are who we are because of our experiences, so I apologize for leaning hard in election law, but it's the one thing that I did the most of. Long time ago, pre-McCain-Feingold, there was a dispute, rulemaking rather, over whether or not telephone calls required disclaimers, the paid for by kind of thing. And the FEC couldn't work it out. They passed a rulemaking on other aspects of disclaimers, but they could not cobble together the statutory required 4 votes to promulgate a rule on whether or not telephone calls required disclaimers. So, the view of the commission at the time, and many people at the time, was phone calls didn't require disclaimers. And I had a case within a couple years before McCain-Feingold came along. McCain-Feingold, it's one of the things McCain-Feingold changed. It expanded disclaimer requirements, in part because it wasn't clear in the previous statute how far the disclaimer requirements went. I remember I had an enforcement case where the staff at the FEC took the position that, oh no, the phone calls do require disclaimers. And I said, oh no, they do not. Went back, pulled the rulemaking and said, look, this was before the commission. The commission did not promulgate a rule on this. You cannot now say in an enforcement case you need disclaimers. Oh yeah, sure we can. Well, I ended up winning the case because that tended to be, the norm when I got involved with those kinds of cases. But it was amazing to see it. I remember another case, it's kind of a related thing, where the staff had written a brief that began something to the effect of, neither the statute nor commission regulations speak clearly to this issue. And I thought, this is great, I'm going to win. But the thing's like 50 pages long. Well, the next sentence was, therefore, we need to look to the intent of the law and commission enforcement precedent and the like to ascertain the applicable standard, something like that. that's just one agency, happens to be in an area of fundamental First Amendment liberty, but you see this move in agencies across the board. It was not a smart move to actually put in writing to say the statute and the regs don't say this is illegal. There's much more clever ways of sort of covering that up. But all this that we're talking about is designed to get at that kind of behavior where you just organize your affairs in reliance on what you think is the understood norm, and then years later something turns over, agency head turns over, staff turns over, people forget their own history, and then they try to spring something new on you. Telephone disclaimers, again, not the end of the world, is kind of a form of compelled speech because you're making you say something that you otherwise wouldn't say. That really stuck with me for a long, even to today, that can happen, where you just go along and as a lawyer, you're advising clients on, no, you don't need them on phones because this is we're all set here.
Sure.
And then all of a sudden somebody says, oh no, we think there's an argument that we could say that you need them. Well, sure, there's an argument. That's not law.
But we're looking at an SEC case right now where what you described at the FEC is exactly what happened. There was an attempted rulemaking. The SEC did not adopt the rule, and now the enforcement division is trying to trying to pretend as though the law, or pretend as though the rule passed when it didn't.
Right. Well, that's the problem with using enforcement as rulemaking, right? Is that it encourages, if that's okay, if courts allow that to happen, we have a real problem, and part of the executive order is designed to prevent that. Because you have a situation where agency heads, particularly in these agencies where you have sort of a bipartisan group of commissioners, will hang back, make the reg a little vague, and live to fight another day, and then try to spring the theory to enforcement. Right, and this happens at a number of agencies. Happened at where I was, the FEC, where constantly you're shaking your head and you're saying, "But you can't spring this in enforcement. You didn't have the votes when it was time to pass the rule. That doesn't mean you get to sort of dust it off and try again and try again and try again. That's not how it works. That's why you have the APA." Disappointing that that's happening at the SEC, but it's not isolated to the SEC or FEC or any of these other agencies. It's a common thing. And I don't get it. You have a rule. Rule is supposed to be there. You're supposed to follow the rule or don't follow the rule. And if you don't follow the rule, then there's consequences. But there can't be consequences for not following something that's not the rule.
Right. Another aspect of the EOs says that agencies have to provide an opportunity to targets to be heard before taking any enforcement action, and they can object, and the agency has to respond in writing before proceeding. Does this get back to the Sackett issue you were talking about before? Is this to prevent massive fines from building up before
Yes.
someone ever gets their day in court?
I mean, Sackett's the one that went the distance to the Supreme Court. The idea that bureaucracies can sort of grind on you and you don't get an opportunity to be heard, or heard by someone who actually has sort of decision rights over, like real decision rights, not somebody down in the bowels who sort of has to report to somebody. It also goes back to my tenure at the FEC. The FEC had a number of, and part of this was based on its history, number of processes where really people who were accused of wrongdoing didn't get much of an opportunity to be heard. The agency, when it first opened its doors, was much more staff-driven. Commissioners could have other employment. Statute eventually changed where they became full-time jobs. So the commissioners had time to actually read everything. And there were a number of things where you just didn't have a chance to be heard. You could get in an audit, go through the audit, and long story short, you would essentially end up in an enforcement case with a vote that there's a reason to believe you violated the law without really having a chance to file any sort of legal brief as to why the auditors didn't have the law right. And then when they got into enforcement, the enforcement people would say, well, the commission's already approved this legal theory. And then, you'd have case would close, you'd ask a commissioner, hey, what are you doing? Oh, I didn't really think I was approving that. I didn't do that. No, you did. That's what the staff said you did. So, as I broaden my
practice in other regulatory areas, I saw this move in other agencies where things take on a life of their own, and you never really get a chance to be heard in a meaningful way at the critical time. Right? You can file. I mean, filing a brief after the decision's been made and after they already are brandishing fine. It's too late.
Sure.
Right? You have to file it at the right time when the decision's actually being made. So that goes to that idea. But sack it is really the shorthand for how that can really just go off the rails.
We're going to open it up to audience questions here in a minute, so be thinking of your questions. But let me ask you one more before we jump to the audience. What can groups like NCLA do to help the process along? And we can certainly host events like this, file comments with the agencies as they promulgate the rules in response to the executive orders. But what more should we be doing?
Comments are very important. Having been in an agency where we did some rulemakings, it was always frustrating when, I or others wanted to do something and it wasn't really in the administrative record. As an agency head, you could have the best intentions and be the most pure of heart, but if it's not in the record, it's tough to get to that result that you desire. And if you get there, you'll be picked off first base in court because it's just not going to be in the record. One of the trends you see in litigation is now courts are starting to take a harder look at the administrative record. This may be sort of only in the era of Trump. So certain judges are looking at that, but long term, if they actually hold agencies to the rule of it has to be in the record, I think it's a healthy development. What else can you do? Academic work is very important. There's not a lot of scholarship on some of these issues that are really emerging.
About the pathologies of the administrative state?
Yeah, I mean, for example, takings. When they move the goalpost to a point where it becomes a taking, there's some thought on this. There's been a couple judges that flirted with it, but there has not been a lot of work on it. Why a lot of this stuff matters in plain English is also good because it's very easy to sound wonky and kind of inside the beltway on this, but how does this actually translate to real people that have real harm? Why the Sackett case is so good, because the facts are so clear and the wrong there is so easily explained.
Sure. That's why it was good the president had some real people there when he signed the executive orders,
right,
kind of telling their story.
That's right. So, and the third, I mentioned this a little bit, is explaining this stuff in plain language that people understand. When you start going through, and I'm guilty of this all the time, talking about Chevron deference, Howard deference, Skidmore deference, State Farm. We talk in jargon here in the Beltway. Eyes glaze over. But where that jargon comes into play is in law schools, where you teach fresh young minds a different way of thinking. Because if you go to typical law school, administrative law is not really yet caught up with where it is in the courts, or at least where it is, among some justices, which eventually probably will be the law. We saw this recently in the Kaiser case where they jettisoned previous deference, sort of imposed a little bit of a murky test, but enough justices were clear that Chevron appears to be in play, right? I'm not sure that's really being taught in law schools. Same as with constitutional law, right? Constitutional law for years was taught usually by someone who clerked for Harry Blackmun and, wanted to teach you how to get the Powell vote. And that passed for constitutional law, right? Judge Bork called it trendiness made complex. How schools teach this area of the law and why administrative law is not just some regulatory thing. It really goes to the heart of separation of powers and really sounds in constitutional authority of the various branches is something that I think we need to get a much better job of pushing out. And then, finally, I remember, I rarely talk about actual moments in the White House, but I remember there was a day I was in my office and Steve Bannon comes in and with someone who I don't think I had not met in person. And he starts explaining to me all this stuff about administrative stuff. And he had sat in interviews of potential Supreme Court justices, and he had heard some of the questions and the administrative questions, and he's like, this guy has this book, and he's like this book, and I'm like, yeah, Steve, there it is on my desk. He's like, oh, you've already read it? I said, yeah, we have a whole box. Here we are. We hand them out. Everybody has these, and he's like, really? So things like this really matter, because this does not look thick, right? There's no pictures, but the administrative threat, and you read this start to finish, and this gets you a long way down the line of what matters. And I had this on my desk in the White House, and Steve was so excited. He's like, "Oh my God, you're really ahead of the curve." I said, "No, actually, Hamburger's the one ahead of the curve. We're just copying his stuff." But that's the sort of thing that really matters. And then finally, sort of to dovetail off of that, to the extent that people actually are willing to take jobs in the government who are familiar with these concepts, read these kind of publications, and try to actually be serious about it, goes a long way. Otherwise, we're all just kind of having panel discussions, talking amongst ourselves.
Right.
So, part of it is educating the next generation, doing some scholarship on the side, and then actually having people who actually are willing to go through what it takes to work in government nowadays, which is a whole other topic, who are actually willing to try to actually, get this kind of stuff moving.
Questions for Don about the executive orders? John?
Thank you. If the guidances, when they're promulgated, have a statute listed that they rely on for that guidance, do you think that in litigation the courts will tolerate if the agencies shift away from whatever they put on the website and say, no, this law also supports it?
Courts should. They should. I mean, they shouldn't allow sort of a moving target there. Time will tell. I mean, I'd love to say, if I were a judge, but I'm not, right? So time will tell. But that's part of why you want the guidance tied to some kind of fixed statute or reg, so at least you kind of know what you're shooting at. But I've had this happen in cases where they pull up another section of the statute and say, well, this actually supports our theory too. And you say, well, okay, that would have been nice to know like 3.5 years ago when this matter started. We'd probably still be here today, Your Honor, but, at least I could have briefed it.
Larry?
What are your thoughts about so-called friendly lawsuits where a public interest group will sue an agency with the expectation that soon thereafter they'll negotiate a settlement subject to court approval and review, requiring the agency to issue certain rules or guidance, not only in terms of a schedule, but sometimes in terms of substantive parameters?
Well, courts have to take seriously the case of controversy requirement, standing, actual harm, and the like. But we do see suits brought by folks who seem to be kind of shill plaintiffs who are funded by others trying to create new law. 9 out of 10 of those cases are trying to create more regulatory law. 1 out of 10 are trying to peel stuff off the books. And that's an easier case because that's an easier kind of harm, that sort of thing. But you see it in a couple different ways. You see this idea that you have these lawsuits that create kind of a court-sanctioned extra statutory, extra regulatory regime that then the agency gets to use down the road on others. You saw this in the world of antitrust over the past, I guess we'll say 10 minus 2 years. I can't say the past 8, so I don't know how, the last administration, a lot of these consent decrees where they go into court and create kind of a whole new thing that's not really antitrust law, that then they use on the next hapless person who comes into the agency and says, well, this is the new norm. Courts, I think, should be a little more vigilant at times on some of those. The other move is it's a variant of agency capture, which is the idea that certain interest groups believe the agency works for them and they expect the agency to do their agenda. I saw this at the FEC. There's kind of a reform industry, well-funded. Not a lot of them, but they've been hanging around since Watergate, and it's the same crowd. I call them my fan club. And it's the same old thing all the time. And, a lot of them, their life's work went up in smoke when Citizens United came down. But that doesn't mean they go away. And I remember after McCain-Feingold, there were a number of lawsuits brought by one of the authors in the House challenging the FEC rulemakings, claiming that they were gutting the statute. They really weren't, but that was the lawsuit. And it was an odd thing to see the reformers basically arguing on behalf of the lawmakers saying this guts the statute, and the FEC lawyers who, really wanted the statute to be read the way the reformers wanted it to be read, both at the podium. There was no one else in the case who could say, wait a second, this is actually a fair read of what's going on. It's kind of, the fix was kind of in. So then it ended up in, remands to the agency that passed broader rules. And say what you want about the commissioners, at least they're appointed by the president and confirmed by the Senate. So the folks who actually were put in power by the people who run the country, which are the people who elected representatives to pick these people, were sort of boxed out of that system. So it's a great question. It manifests itself in a variety of ways. But it's another way to create rules kind of out of whole cloth that then are tough to ascertain. Not so good. Variant is also, the nationwide injunctions is kind of another one of these moves where, I thought we kind of had one Supreme Court, and then we have, statutory courts of circuit courts and district courts. Nationwide injunctions completely obliterate that, and essentially one judge can set the law for the entire country, and it kind of destroys what had been the model of competing thought, circuit splits, and then the Supreme Court resolving a handful of issues on that. So that's another time where you see, expansive use of things that don't really come from statutes or lawfully promulgated regs to create law.
I agree with you completely. We do not do nationwide injunctions here at NCLA, and we do see lots of lawsuits out there brought essentially to circumvent notice and comment rulemaking. Don?
Yes, I wanted to ask if there is anything in the executive orders that makes guidance documents binding on the agency. So the agency cannot announce one rule in the guidance document and then enforce against a different rule. I thought that was resolved by the Allentown Mac case. But as you know, we were unable to convince the administrative conference in its two recent recommendations about guidance documents to say, as Peter Strauss had written, I thought back in 1992, that they're not binding on people outside the agency, but they certainly do bind the agency. And so now these administrative conference recommendations simply say the agency has to disclose whether they are or not binding. Is there anything in the executive orders that would say you can't announce one rule and then enforce against another?
Well, I think this is the point of having a process on how the guidance actually gets promulgated and put together. The idea that there needs to be rules on the rules. Whether there's some, I don't know.
For finalizing the regulations to issue guidance?
Yeah, right. And I think that'll help address that. Again, I go back to governing is about getting done what you can get done while you can get it done. And hope that then the next person in line behind you continues and takes it to the next level.
I'll take that as a no.
Oh, I'm sorry, the microphone's over here. Inez?
I already got. You mentioned a culture of independence at the agencies for the sake of independence, and then you also have given a variety of examples of how even the people who are appointed, at least by elected officials, get boxed out of certain decision making that actually is making law. Could you speak to the civil service piece of this and whether the fact that folks have so many protections in terms of losing their jobs gives them the kind of independence or that culture of independence to say that my authority doesn't actually flow from elected officials or from voting or elections?
I think that's part of it. And this is going to be something that, people sometimes they boo me when I say this, but I don't want to be overly harsh on bureaucrats for the sake of being harsh. A lot of these folks, they go to college, they're smart, they get a job, they like what they're doing, they're passionate about it. They show up on time in the morning, they go home on time, they put food on the table, and they're not really there to advance some ideological or partisan agenda. And that's, I think, the overwhelming majority of folks who work in these agencies. But then there's the percentage who are not that, and they either kill morale because they just are not workers, and the workers actually don't like them. And then there's the other group that doesn't matter what you tell them, they've got their own agenda. And that's really the problem child. And when those folks get these multiple layers of employment protection and are able to weaponize, union grieving processes and the like, that's where it really gets to be a problem. You know, it's interesting that the idea that there's like unionized lawyers in the executive branch. I didn't pass judgment on it, but the reaction of the audience kind of tells you what we think, what is thought of that. You know, and the running joke is, you know, you're sort of, you know, like, you know, the buzzer hits at 5 and you drop the pencil halfway through the word "the," and then you come back at 9 o'clock in the morning and finish the word and keep going, you know, because that's the union thing. But this stuff can get weaponized, and it does give people a sort of protection. The more frustrating thing is the amount of power that agency heads have given away over the years. When I was at the FEC, I was surprised to learn that people under a certain GS level, GS scale from, you know, up to GS 15, on a pretty high schedule level, the commissioners did not approve. And I did some research on it, and that was not the historical norm. Commissioners had approved people down the chain quite regularly. And, you know, it may have just been, okay, fine, whatever you want, you know, kind of a rubber stamp, but at least that's a stamp. But over time, the agency head had given away that power, so you had very little say over who worked in the agency. So we can blame the civil service laws, and I think they can easily be weaponized, but we also have to hold accountable the people at the agencies for not using the power they actually have. And so that's, you know, it's not as simple as just as one problem. It's a multitude of problems that cause this. Third, the independence comes from kind of an ideological, agenda-driven kind of thing where you just don't really like what the statute says. You want it to say something it doesn't say. You didn't have the votes in the legislature. You see this move, right, where Congress will pass these statutes that are kind of a little vague, a little unconstitutional, and there'll be this big fight and, you know, over some language, and then the language doesn't go in the bill, or there's sort of a catch-all phrase, and the team fighting against that language has a victory party for themselves. And then it goes over to the agency, and the agency just writes it right back into the statute, right? So there's this other sort of, and that has nothing to do with civil service laws. That's just an agenda-driven thing where you just are not accepting of the premise of kind of three branches of government who has the legislative power in the country.
Richard Coleman, CBP, retired. With respect to the continual concerns about the growing power of the executive branch and the punting of the legislative function, and following up on your comment, what is your assessment about the problems with this administration's use of acting positions? Does this thwart any significant oversight, and, you know, should that be something that's corrected down the line?
That's not on the executive order, so if you don't feel comfortable speaking to it, that's fine.
Well, it's not that I'm uncomfortable. I don't have a real problem with actings, to a point. President's so far away from getting near the line where I have a problem with it that I think he's right. It does give him some more flexibility. Let me take it head on. Look, this president is the first president who has not had a recess where he could do recess appointments, which is something that goes back to the founding. And that's due in large part because of the Noel Canning decision of the Supreme Court, which my firm actually litigated and won, and then now, you know, it kind of has caused, you know, it's one of these things. You do the right thing in the moment, and situationally, it may, you never know how it's going to tilt. But every other administration, by about May of its first year, has had a Senate recess that then allows the various levels of presidential appointments to at least be filled. And then there's a deal later on in the Senate where they kind of go through and they're confirmed by the Senate. That hasn't happened. So that's really put this president at a disadvantage, timing-wise, that no one else has had. That, you know, it took him a lot longer to kind of get his people in place. Second thing that's happened, and this is not something that just happened overnight. This has been something becoming decades and decades and decades, is that the Senate is not the fastest gun in the West when it comes to confirming people. And that's not something that can be fixed overnight. Senator McConnell's done a lot to try to streamline it,
but it's not something one man can do or even a majority vote can do in the Senate. It's built up over years, from the blue slip for judges to how they just take routine nominees to everything in between. It is very, very slow. President has a 4-year term, and it's very easy to wait him out and to slow walk a variety of appointments up and down the line, and that's not fair to him. So, he doesn't really have a choice but to do kind of acting sort of things. The Congress has empowered the president to do this through the Vacancies Act, right? There are ways to shift people around into various acting roles, and Congress. That's a way they've kind of ceded their advice. The flip side, they kind of ceded their advice consent role in a way by doing that, but it's because of the very practical reality that you really should have people that are accountable to the president somehow in these positions. Now, the actings that get kind of tricky are someone who's a career person who finds themselves as the sort of highest person on the chart, and they default being in charge of something. That's not really what I have in mind with who's supposed to be making these decisions. So that's a little bit of a problem, but that's caused by a lot of the other factors that I talked about. So it's a good question. It's beyond the scope of the executive order, but why not? I'm here. I'm mic'd up, got the camera rolling. Let's just wing it. What could go wrong?
Last question is there an aspect of the executive orders we haven't talked about that you think is important or one of your favorite parts of the executive orders, or if not, is there something maybe we did talk about that you would like to single out as being particularly important?
Well, the thing that it doesn't really matter if it doesn't get through, but it kind of goes back to one of your first questions, like who gets credit for it? Well, the president gets credit for it. None of this happens without him. Judicial selection, all this. I mean, it's say what you want about him, but that he said he'd do certain things and he's doing them. But the origins of the EO, I had done a memo to general counsels laying out a lot of these concepts. Rachel Brand, when she was associate AG, she likes to call it the Brand memo.
Right.
That's actually what we call it. Jeff Sessions put out a similar memo. Jeff and Rachel's memos were codified into the DOJ folklore, their handbook.
And they've rescinded 125 guidances at DOJ.
Right.
At least.
At least. That's at least ones we know about. My point, though, is that this was done, started out informally, a little more formal, to the point now you needed an executive order. So it's interesting, the evolution of it, how it really, if you go back, the executive order comes out now, but these concepts were being pushed from day one. And the fact the EO's out there answers some of your questions about are agencies really going to listen to this? Well, they weren't quite listening to, people who had sort of forcefully suggested this before.
Right.
Now they don't really have a choice. The president has spoken, and if you want to work in the executive branch, that is the voice that matters.
Terrific. Well, join me in thanking Don for being with us today.